Okay. We will now hear oral evidence from Professor Sir Chris Whitty, Chief Medical Officer for England, and Duncan Burton, Chief Nursing Officer for England, NHS England. Before calling the first member to ask a question, I remind members that questions should be limited to matters within the scope of the bill. I'll also remind members that time is tight, so please keep your questions to the point. We must stick to the timings in the programme motion. The committee has already agreed, and for this section we have until 10:05 a.m. So could the witnesses please briefly introduce yourselves for the record, and if you are to give an opening statement, please keep it short. Thank you very much. Sir Chris Whitty.
Thank you, Chair. I'm Chris Whitty. I'm the Chief Medical Officer for England, also representing the Chief Medical Officer for Wales. One statement which is on behalf of both Duncan and myself and all the CMOs is we are completely neutral on the principles of this bill, which we consider are entirely for society and therefore for Parliament. So although we're answering technical questions, we will not be answering questions of principle because we feel that is a societal question. We have made clear to the medical profession, however, that individual doctors should be able to make whatever statements they wish, and obviously doctors have strong views on all sides of this argument, as members of society do.
Good morning, I'm Duncan Burton, I'm the Chief Nursing Officer for England, and also just for transparency I'll just say that I am also a volunteer trustee of a hospice.
Thank you very much indeed. Those who want to ask questions, please indicate. Nasha?
Thank you very much, Chair. Thank you very much for that. So, Chris, if I could ask you, if I can draw your attention to clause 42.3, especially the part which states, but if any provision of this Act has not been fully brought into force by the end of a period of 2 years, beginning the day on which this Act is passed, that provision, so far as not already in force, comes into force at the end of that period. The question is, do you believe that it would be safe to implement this legislation if those provisions have not been fully put in place?
Well, I think that the key thing, if this bill is passed, and I want to stress, and I'm going to say that once, but assume that for all the answers I subsequently give, if this bill is passed, what we will clearly need is both a period of time to make sure that there is technical, both guidance and legislation via secondary legislation, because obviously the primary will be through the bill, but also necessary training for people to be able to do this in an appropriate and dignified way, if that is what Parliament chooses.
So would it be safe?
Well, I think that what we would want to do is to have the time to do that, but you can do things at speed if you need to. My view is this is something which is best not done at speed if we can avoid it.
Right, thank you. I'm former NHS Commissioner Sir Chris, and in Bradford West we have high, stark health inequalities. Dr Jamila Hussain, as part of John Wright's team, will be providing evidence this week, and she's found huge mistrust amongst marginalised ethnic groups, and even more so since COVID. And we know that COVID brought to light the inequalities in healthcare access that already existed, especially for economically disadvantaged communities. What lessons do we need to learn from COVID and its disproportionate impact on ethnic minority communities when it comes to this bill in particular and its implementation?
I think that's an absolutely critical question, because it is very important that if the bill is passed, that all parts of society, of whatever ethnicity, of whatever background, have equal access to the bill or not, as Parliament has determined, and that is going to require adjustment in a variety of ways. Some of them can be done at a macro level, for example, making sure that everything is translated into the major languages spoken in the United Kingdom, but a lot of it will be to do with the individual interactions that doctors, nurses and other healthcare providers have with individual patients that must take into account their own starting point, their own knowledge and, of course, most importantly, their own beliefs.
Thank you.
Thank you. So, Chris, you mentioned there about having time to ensure that people were appropriately trained, and the Act as it's drafted includes provisions for Secretary of State to make orders around required training. Could you say a little bit more about that if Parliament did decide to pass an Act of this nature, what training requirements do you think would be helpful and required? And I think I'm thinking in particular around skills around capacity, and the assessment of capacity and coercion.
Thank you. So I'll give a view, and it might be useful to get Duncan's view also on the nursing side, because nurses very often will be involved heavily in these discussions. So I think I would divide the kind of training that is needed into two broad groups. Training which is essentially normal medical practice but may need some variation, and things which are clearly specific to this bill. So issues, for example, around mental capacity, as determined by the Mental Capacity Act, is something which is done every day in every hospital up and down the country. Every doctor, every nurse above a certain level of seniority should be able to do that normally. It may require some slight adjustment around this. There's an absolute expectation within the Act, for example, that the more serious the decision, the greater the level of capacity that someone needs to have. And that is already built into the principles of the Act and the way that things are done. So those forms of training, and I would also extend that to, for example, the management of end of life, which should be a normal part of medical practice and nursing practice. We will all die eventually, and it's important. That has always been part of medicine and always should be. That should be generic, but may need some adaptation. Then there will be some specific things which will be necessary for people to understand this Act and to, in some cases, take part if this Act is passed in the final part of prescribing drugs to patients. Now, I think it is much more likely that a very large number of doctors and nurses may get involved in the very earliest stages, because someone may raise an issue with their GP, with their nurse, with their consultant, and they need to have the basic understanding for that. When it comes to the more detailed later stages, that, in my view, will require some specific training. And I think quite a lot of there will be a gradation, in my view, of doctors, ones who are happy to have the general initial conversation, ones who are happy to have the structured conversation that follows, and a minority of those who will be happy to go on to take part in the final stages. It is very important that both the wishes of the patient are respected, and that is the central point of this. We must start with someone in their last 6 months of life and their immediate family, what's good for them, but we must also make sure that the wishes of healthcare professionals around this area are absolutely protected, both from conscience and indeed through choice. Duncan.
Yeah, I mean, I would add to that just to say that, you know, I'm mindful that there are almost two groups of staff here, staff that would potentially be working in this service if this Act is passed. But also the wider workforce. So at 2 o'clock in the morning, when a patient wants to have a conversation with somebody about end of life, it's going to be a nurse that's going to be with them, or it's going to be a nurse in a care home, or it will be, you know, a specialist nurse providing cancer care. So we have to think about the training and support that's required to them, be that around signposting or explaining where they can go to access more information. So there's an important part about the entire wider workforce we need to think about. And then clearly for those people that are working in such a service, thinking about the safeguarding elements of this and how we make sure that the support around safeguarding training, confidentiality, particularly mindful that some patients may choose not to tell their families about this, and how do we enable and support staff in managing those kind of circumstances and navigating the legal requirements through this bill. And then obviously thinking ahead around what we would need to do in terms of undergraduate training, both for doctors, nurses, and thinking about the curriculum.
So if I may, Chair, just one follow-up on that. So at the moment, clearly, I'm aware that there are instances across the NHS every day where people make decisions around refusing treatment that it would be required to perform their lives. And I think doctors, nurses, and the healthcare team would be involved in assessing capacity and indeed coercion around those. Can you say a little bit about any learning from that, and I suppose the levels of skills required in the current practice around refusing life-saving treatment, and how that might be taken into assessment under this Act?
You're absolutely right that it's a completely normal part of medical and wider nursing and other practice, but particularly medical practice, to consider issues of consent and issues of capacity. And it can be where someone says they don't want treatment, and that could be a treatment which is clearly going to be life-saving. A very well-known example is the example of people who are Jehovah's Witnesses who choose not to have blood products. And if they're bleeding heavily, that is an issue which could lead to the end of their life. And provided they understand that and they have capacity, that has to be respected. The alternative way, and the other thing which doctors have to do, is give people advice before they have made, for example, major operations or chemotherapy or other drugs, which may itself lead to the end of their life, but also may lead to a benefit. So explaining to people the risks and benefits, including the fact that they may lose their life as a result of the next stage. And if someone's at high anaesthetic risk, that is not a trivial risk sometimes with operations. That is a very standard part of medical practice that you do essentially from the point you qualify. Obviously, as people get more senior, they tend to be more experienced in it. And as with most things, if you get more experience, you generally get better at it.
Sarah Olney.
Thank you, Chair. Professor Whitty, I just wonder, the definition of terminal illness is attracting some attention, and some people are saying that it's difficult to define a terminal illness. I wonder if you think it would improve the bill if we could have instead a specified list of illnesses that would apply under this Act. Do you think it's possible to come up with a list of illnesses that are terminal that would qualify under this Act?
I think it's, if I'm honest, I think it would be extremely difficult, and if I may, I'll explain why, because I think it's a really important question. Let's take cancer. For the great majority of people with the majority of cancers that are diagnosed tomorrow, the doctor who's seeing them will say, in all confidence, you have cancer and I expect you to be alive not just next Christmas, but for many years to come. So the fact they have cancer is not in itself a demonstration that they're going to die, and in fact, the majority will not. Almost 80% of people with breast cancer diagnosed tomorrow will still be alive 10 years later, for example. Equally, there are people who may not have a single disease that is going to lead to the path to death, but they have multiple diseases that are interacting in the same person. They're highly frail, and it's not the fact of one disease that's the cause, but the fact of this constellation that is clearly leading them on a path inexorably to a death at some point in the foreseeable future. Exact timings are tricky, we might want to come back to that. But therefore I think it's quite difficult to actually specify these diseases are going to cause death and these diseases are not, because in both directions that could potentially be misleading.
So can you just perhaps talk a little bit further about whether you perceive any difficulties with having a definition of terminal illness within this Act, and how do you think the medical profession are going to interpret that?
Most, so at the extremes, and most people are at the extremes, it is very clear what's going to happen. So for most people, you can say with confidence that barring some extraordinary accident, like you're hit by a car on the way out, you'll be fine in a year, even though you have heart disease or cancer or whatever. At the other extreme, there are people who are clearly dying and will die in the next 2 or 3 days, and there's virtually nothing that's going to change that reality. What we're talking about in this Act, of course, is a point between those stages, but people definitely reach a point where there is now going to be inexorable and I think importantly for this bill, unreversible slide towards a point of death. And people can make a reasonable central view, if they're experienced in a particular disease, about when that death is likely to happen, accepting that there is a spread around that. And I'm sure that the general public and members of Parliament fully accept this. This is not a precise science. This is a central view, and there's a big academic literature around this. Some people will die significantly earlier than they're predicted to. Some people will die, and a small number will die very significantly later. Some people will certainly die a bit later, or to some degree later. But the central view, I think, is usually reasonably accurate, that someone is now in a point of a pathway from which there is not going to be a return.
Thank you, Chair.
Better.
Thank you, Chair. Thank you for coming and giving evidence this morning, gentlemen. I'd like to pick up a little bit more around coercion and capacity, because I think these are two really important points in terms of the bill. And I'd like to know a little bit more about the work that doctors and nurses do in terms of checking for coercion and assessing capacity when patients are making really important decisions and choices at the end of life, but also maybe in other contexts as well. And if you think, I mean, we refer to the Mental Capacity Act in the bill. I mean, the Mental Capacity Act is a big piece of legislation, but I'm very conscious there's only a short reference to it in the Act. If there's anything you think we could add to the bill that would maybe improve the robustness of that reference to mental capacity. So what does it look like now, and is there anything you think we could add?
Duncan, why do you take the first bit and I'll take the second?
Yeah, so I think just in terms of looking for signs of coercion, etc. So we all of our nursing staff, all of our clinical staff have safeguarding training, and that already looks at things like, are people being under financial coercion, for example, or other forms of abuse. So that training is already in place and is extensive across the NHS, across social care. So I think if the bill is passed, we will need to look at how do we strengthen that in relation to spotting the potential signs of coercion in this space as well. So, but given that mechanism is already in place, I think that would be an extension. So it's important that we factor that in. And I'm also mindful about, given the scale of that, given the scale of colleagues that we have working across health and care, that the time between if this act is passed and the implementation is sufficient that we enable everybody to receive that additional training if it's required.
Yeah, I think in terms of strengthening the bill, I was, as a practitioner, relieved that the decision of this bill, if it stays in this way, was to stick with the Mental Capacity Act for two reasons. The first of which is this is used up and down the country by doctors and nurses every day. They know it, they understand it. Although, as you say, it's a large piece of legislation, it's one which people have worked through in practice multiple times. And if you ask 6 or 7 doctors, does this person have capacity, in almost all cases, then you'll get 6 or 7 identical answers because people are used to using it. It additionally has the advantage it's been tested in the courts. So this has gone as far as the Supreme Court, and the various sort of ambiguities that inevitably were in the legislation there have been clarified by senior judges, therefore meaning it feels to practitioners like me a piece of robust and predictable legislation. Within it, it's very important that there are some situations where you will need to call for additional assistance. So, for example, if someone has a coexisting mental health condition, you would probably want to ask additionally from a psychiatrist, is this interfering with the decision that's been taken to the point that someone loses capacity for this very important decision? So the level of capacity has got to be reasonably high. So my own view is that starting with this is the sensible thing to do. That doesn't mean there couldn't be arguments for some additional points around it, but I can't immediately, again, as a sort of jobbing doctor, see ones where I think this is going to make a big difference. It's the fact that there is a very established bit of well-used and well-recognised legislation that this is founded on.
And if I may, Chair, just to follow up on that, and to that point, in terms of those conversations where patients are making very serious decisions, it's not uncommon that you would seek additional advice from other professionals, such as a
Correct.
psychiatrist, possibly such as a social worker, such as other professionals, if you felt there was a need to do so.
The further you go up in terms of the seriousness of the decision, the more you would do that. So if you were, for example, setting a finger that are broken, you're not going to wait until a psychiatrist has said you can do that. Within reason, you can, provided someone gives consent, you'll do it. If you're going for open heart surgery, or if you're going for deprivation of liberty, those kind of things, you'll be much more cautious about moving forward if you think there is uncertainty. But it should be clear, for the majority of people, it's either very clear they have capacity or very clear they do not. Yeah. There's a relatively small number, important number, in the middle where that is less clear and where additional views, particularly if there's a question of coexisting mental health issues, are relevant. The fact of a mental health condition does not in itself mean someone has not got capacity, but it has to be taken into account and they do have the capacity for this decision at this point in time, which is how the Act actually works.
Brilliant, thank you.
Rebecca Paul.
Thank you, Chair. The bill sets out that it should be brought into force within 2 years. If the intention is to provide assisted dying through the NHS, can the NHS be ready in time to deliver this service equitably and safely? And what needs to be deprioritised in order for it to do so?
Well, I think, as was seen in COVID, the NHS, like any service, can swing very fast if there is a need for speed. In this case, I think most people in society would say the key thing is to get this right. So I personally, I would rather this wasn't running against a timeline. You wouldn't want it to drag on forever because then you have uncertainty for everybody. But certainly I think Duncan and I would both say, 2 years seems a reasonable starting point, but some things might take longer than that. To work out how we're going to provide this in the most safe, equitable way, dealing with minority and other groups, for example. We need to get all that right and at least at first pass, get it as close to good as we can possibly do so. Equally, and this is why I hope that some of the more operational issues are done for secondary legislation and regulation, we may find when we first start using it, there are some things we hadn't considered at the beginning, and that therefore we need to go back and improve on because we just hadn't thought about it in the first way through the gates. And that's true inevitably for many bits of legislation, but that's particularly important here. And I think I go back to my very first comment really. The central person here is a person, an average citizen in their last 6 months of life. What we don't want is a system that is very difficult for them to navigate, so they spend their entire last 6 months of life, if this bill is passed and they choose to take account of it, which is in the minority, essentially stuck in a bureaucratic thicket. We do need to keep this simple, and my view is the best safeguards are simple safeguards, so overcomplicating actually usually makes a safeguard less certain, to be honest.
So, in your view, what is a reasonable time frame? And I appreciate it's a little bit how long is a... What would you ideally like to see in terms of...
I think that there's a big difference between the Act coming into initial force, this is now where the law is, and the service being provided. And on the second of those, I would argue against putting a firm deadline on it, with a reasonable expectation that the NHS and others should be involved in trying to make plans for this as fast as possible. But I think if we're sort of 3 months away from being able to actually get something sorted out, given there are multiple different things we're going to have to sort out to get this to work if the Act is passed, I wouldn't want to have a sort of it must start on the following day, because I think that would make it much harder to provide a safe, fair and secure service. Duncan, you want to add to that?
Well, I think just to add, I think my understanding of the bill, it doesn't specifically call out the NHS as the specifically in terms of providing this service. So I think there are a number of steps that would have to be go through to understand the implications of this, the operational implications, the training implications, as we've already discussed, to understand the timeline required. But, I think for the reasons Chris has outlined and earlier thinking about the wider implications for the workforce, it would need to be a sufficient time to be able to work through those.
So would it be fair to say you would need to know fairly quickly whether or not it would be provided through the NHS for planning purposes?
I think that is a key question. And I think, actually, to me, that does seem something which Parliament may want to debate. That's not a question for us, but that is a point of principle, I think, one way or the other.
Thank you. Thank you.
Ms. Saville.
Very much. Question to Chris Whitty, because as you said, you're here representing the Chief Medical Officer of Wales as well. Health has been devolved, of course, for over 25 years. What conversations have you had with the Chief Medical Officer of Wales about the differences in how the NHS operates between Wales and England and the implications for us to know as the Bill Committee?
I think that, firstly, I've had quite a lot of conversations, not just with the Chief Medical Officer for Wales, but all the other Chief Medical Officers, and indeed a much wider range of the medical profession, because this is something I wanted to feel I was giving a central view of the medical profession in terms of the practicalities. My view is the principles of the bill, in a sense, are no different between England, Scotland, Wales and Northern Ireland, although this is only England and Wales that this would apply to were it to be passed. The operational kind of questions we've been talking about will be either subtly or importantly different between the different jurisdictions for a variety of different reasons. And I don't think that is a problem, provided it's in secondary legislation and it allows the different jurisdictions to actually do it in the way which best suits their own setup. Because, and again, as we saw during COVID, different nations will choose to do the same end state using slightly different practical routes.
Okay, so if I could just develop on that a tiny bit, in the sense of the timeline, in that case, you would see that possibly being different, say, for England, for Wales, in order to respect and take account of those operational differences?
Yes, I think in principle it'd be better to be as close as possible, but I think if there were important practical differences to why it's not going to start on the same date, the more important question is to get it right, rather than to get the simultaneous timings.
Daniel Francis.
Thank you, Chair, and thank you, gentlemen. I hear what you've said already regarding capacity. Of course, the Medical Capacity Act relies on the three capacity principles, which is the presumption of capacity, that a person can't be held to that capacity unless all practical steps have been taken to support them to make the decision, and that a person cannot be held to that capacity merely because the decision is unwise. And I also heard what you said about that scaling of decision making, but of course within the Act, in some of those scenarios there's no mandation, the word may is used rather than the word must. So I'd like to understand your viewpoint on whether those parts of the Act were taken and tightened for may rather than must, and whether there's a definition of ability, which is within our amendments before us to delete the reference to the Capacity Act, instead have a separate definition of ability, if that were to be there, whether you believe that would provide stronger safeguards.
I think the exact drafting of the bill in terms of may and must is probably, I'm not the best person to ask, but I can ask the second part of your question, which I think is really, really important. Were there to be no Mental Capacity Act, I think there would be an argument, which has been used for a long time. I think this bill would clearly have to define what was meant with a fair degree of clarity, and it wouldn't be able to do it with just one clause. It would have to be quite a lot of clauses, if I'm honest. The reason why all systems of this sort are going to be imperfect, the reason I think it is sensible to base yourself on the Mental Capacity Act is it is well used and well understood in practice by practitioners every day, to have a system where you have two completely separate groups of assessment, one of which has never been tested in the courts and has never been used out with this, would, I think, lead to a whole set of potential complications and ambiguities which are not there because we've got a well-tested mechanism through the Mental Capacity Act. So I think people should move away from the Mental Capacity Act with some caution, because I think it will cause as many problems as it solves. And it's not clear to me what the problem is that people are trying to solve by doing this, given the Mental Capacity Act clearly makes the point that the more severe the decision, the greater the degree of capacity has to be assumed before people can actually take that decision, which I think is at the foundations of some of the disquiet that people have had. But that is very, very central to how the Mental Capacity Act in practice works.
Dr. Simon.
Thank you. You already said some words about prognosis, because that is causing some anxiety with this bill. First of all, are you happy with a 6-month prognostic period? And secondly, in the Act it says reasonably to be expected within 6 months. Are they in line with your thoughts on this matter?
I think, provided that Parliament, in taking that into account, assumes that what we're meaning is a central view, that this is 6 months, but it might be before that and it might be after that, but this is a central view, I think that is a reasonable point in time. Other times would equally be reasonable, but if you're going to choose one, this is a reasonable one at 6 months. It is generally very predictable someone is going to die in the foreseeable future. Whether it's 5 months or whether it's 7 months is a lot harder, and there'll be some caution. And notably, in those countries that have chosen to go down the path of an assisted dying route, a variety of different ones have been chosen, a significant minority of people die before they actually get to the point where that occurs, because there is uncertainty in both directions. But I think it's as good as any other, but I just want people to be clear that it's not an exact science where you can say on the 20th of August, it's not like, for example, it's not as tight as, for example, saying that a baby is going to be born on this date. It has a wider spread of uncertainty around it. But it doesn't mean that, in the overwhelming majority of cases, that doesn't mean it goes on for months and years longer, but there will be some degree of uncertainty.
Okay, thank you. Can I have one more question, Chair? I'm just interested in the opt-out, that doctors, ethically can opt out of to taking this decision for patients. What I'm interested in, should they then have a necessity to steer someone to another doctor, or can they just simply refuse to do it?
I think that is so. Duncan may wish to comment for nurses. For doctors, I think that we should be very mindful of the fact that for some doctors, as for some citizens, this is a point of very strong principle indeed. And therefore I think there will be a gradation of people's feeling that they can personally be involved in this. I suspect for the majority, probably the great majority, referring on if they themselves don't feel able to do this, either because of conscience or choice, or indeed because they don't feel that they have the necessary skills, I think they would have no problem. But for some people this might be an issue. And personally, my view is we should be able to have the range, provided people are aware in general that if one person cannot provide it and does not wish to discuss it, there are alternative routes. But that really is a matter for Parliament. And if Parliament says that's unfair on the patient, because then the patient is having to go through an extra step, that is an alternative and perfectly reasonable principle. So I think Parliament is going to have to balance those two principles. It's not for me as a doctor, but I just think that range of opinion needs to be thought through when people are coming to that final parliamentary decision.
Yeah, if I could just add to that, I think it's really important then that, again, that bit about the wider workforce and how would we support them. We have situations like this already where, you know, we've got advice professionally around things like abortions and working in embryo services, for example, and so and fertility. So we need to make sure that the safeguards there for our staff are really clear, because as Chris has said, you know, we will have a range of views and opinions amongst our staff on this, as there are in the wider public. And so I think that the work you do in creating this bill is really important in terms of what advice do we give to people about signposting and you know, having those conversations where actually our clinicians are having conversations every single day about the choices that people have at the end of their life.
Thank you, Chair. Professor Chris Whitty, you said not all mental capacity assessments are safe. Do you think hopelessness, low mood can lead to people's ability to make capacity, and a sudden diagnosis of terminal illness can lead to some of the status, depression, low mood, hopelessness? And do you think all doctors are capable of identifying those states?
So I think that I would hope that most doctors are capable of identifying that someone has some degree of, or a large degree of mental health distress or mental health illness, if you wish. What not all doctors will feel comfortable doing is actually deciding whether that is sufficient to interfere with someone's ability to make a decision with full capacity. And that's where help from colleagues from psychiatry, mental health more widely, is going to be useful. But that should be good medical practice, in my view, under all circumstances. This bill takes it to a high level of need because of the seriousness of the decision that's being taken. But that is part of, you know, I will in my medical practice, Duncan will discuss with senior nurses when he was operating clinically, you know, should we actually get an opinion from a mental health, either community psychiatric nurse, if it's that kind of question, or a psychiatrist or others, to make that assessment. But that's really the question. But certainly what I wouldn't want is to be in a situation where the existence of the fact that someone who has a terminal diagnosis has some degree of low mood in itself just rules them out from any kind of medical intervention, this or any other. That shouldn't be the case. They've got to have access to whatever the state and the medical profession are able to provide, depending on, again, obviously what Parliament decides on this particular bill.
Can I ask a question to Duncan, please? Thanks, Duncan. Nurses who work in stressful environments are expected to get clinical supervision, like people who work in mental health wards. Do you think the nurses who are going to work, if this bill passed through, in those areas would require a specialist clinical supervision? And do you think the NHS have capacity to provide clinical supervision for the nurses who is going to work in those areas?
Well, look, I think you're absolutely right. Anybody working in stressful environments, and if we were to have nurses, doctors working in services, if this bill is passed, then they will need to we will need to make sure that we've got sufficient psychological support for those individuals, as we do now for many of our nurses and other professionals that are working in these kind of situations in terms of end of life, or, you know, cancer nurses, for example, often have psychological support to help them deal with some very difficult conversations with patients. So we would need to look at that and to make sure that there is sufficient support in place for anybody working in these situations, and also mindful about the wider workforce and the issues that such a debate as this and you know, the decisions that to signpost people onto services and how that might create for some people moral injury. So we do need to think about the support that's in place for those.
Thank you. You touched upon it, but if I could just get some further clarity perhaps, certain amendments have been suggested which essentially are more prescriptive in what clinicians, factors that need to be taken into account and steps that clinicians would have to take when considering capacity in this context, but also informed consent and what options are available. Of course, it's a matter for Parliament, but would you err on the side of trusting clinicians' professional judgment within the legal framework as it is, in terms of the Mental Capacity Act, in terms of the guidance on informed consent, or would you deem it suitable for further prescriptive steps to be put into primary legislation in this context?
Entirely a matter for Parliament at one level, but I can give a view.
Yes.
And I think it actually goes back to the point that Naz Shah and others made earlier on. The situations people find themselves in are extraordinarily different. Culturally, where they are in their lives, where their families are, a whole variety of other issues. And only the clinicians who are dealing with that person really will know all the different factors that are playing. And if they're doing, if there's a good therapeutic relationship, which you certainly would hope there is, they should understand a whole variety of things which are very difficult to predict for people sitting around this table, however wise you are, and I'm sure extraordinarily wise, to be clear. That wasn't my point. My point is it's very, very difficult. I could not, at this point, write down a law that would actually be helpful to someone dealing with a whole range of different scenarios where they're going to have an end-of-life discussion. So my own view, for what it's worth, is I would do fewer rather than more. And that is partly because simplicity is the key to really good safeguards, in my experience. If safeguards are really clear and simple, everybody understands them. And if you ask 6 people, what does this mean? 6 people will give you the same answer. The more complicated you give things, the more room for ambiguity and uncertainty, because different things are playing in, the more difficult it is for the patient, their family, and those medical and nursing professionals who are assisting them actually to navigate systems. So I think, without in any sense wishing to curtail what Parliament might wish to do, I would make a plea for simplicity wherever possible and for accepting the extraordinary variety of people's lives, which may have unpredictable consequences in terms of the way that the end of their life plays out.
And so just in terms of setting standards and ensuring universality of understanding those safeguards, that's better done, in your view, then by training, by guidance, rather than primary legislation setting up factors?
I would certainly recommend that this is, if possible, is either done by guidance or done in secondary legislation, which, if it then turns out it's not having the desired effect, can be adjusted to change that. Because two things can change. First of which is we can spot some things we hadn't thought of in the first place, however far-sighted each of us is. But the second is medicine itself changes, the diseases people suffer from changes, and so on. And an act has to be durable, and that's why I think, in my view, secondary legislation and guidance has the ability to adapt in a way primary legislation is much more difficult to adapt. So that the really fundamentals need to be in primary, obviously, but these kind of issues, I think, are often better done in secondary.
I'm very mindful of the time. It's now 3 minutes past, so this will be the last question, I'm assuming, of this session, and I'll go to Jack Abbott.
Thank you, Chair, and thank you, Professor Whitty, and Duncan, for being with us this morning. Professor Whitty, in October you published an advice note to doctors about a range of guidance on this issue alongside a number of chief medical officers. In there you've said that a couple of things are unanimous for the medical profession, but the one I'm kind of focusing on is the line where it says that we must not undermine the provision of good end-of-life care for all, including the outstanding work done by palliative care clinicians. Do we take that by implication that you're fearful perhaps that this bill could indeed do that it could undermine good end-of-life care? And in your view, how might we be able to mitigate against some of those risks within the bill before us at the moment?
I'll give the view, and Duncan will also want to later. The Chief Justice did a parallel bit of advice which said similar things. I think all of the medical profession, all of the nursing profession, all health professionals very strongly believe that palliative care and pain alleviations, which is not the same as palliative care but overlaps with it, and end-of-life care, which is also not the same but overlaps with it, are essential, and in some areas are not to the high standard that we would hope for. And I think that would be common view across the medical profession. My own view on this bill is, my hope is that it will neither, it should not either make that situation better or worse. I think it changes one particular aspect in a very important way. But the principle that we should be improving end-of-life discussions, which is where the end-of-life care starts from, and supporting further the provision of alleviation of symptoms and palliative care, seems to me one that I don't think would have any disagreement from anybody in the medical, nursing or any other professions, or indeed the general public. And I think that must be fundamental to how this bill is sorted out.
Order. That brings us to the end of this allocated session.
Do you want to say you agree or disagree?
For committee members, but I will let you say a few words if you wish to, Duncan, but that was the end of this session.
I absolutely agree with that. I think, obviously this is a decision for you, but what is clear is that the discussion around death and dying in society has increased, and I think that's important. I think it's important that we have discussions and support people with their choices at the end of life. So I think anything we can do to increase that is important.
I want to thank our witnesses on behalf of our committee members here, Professor Sir Chris Whitty and Duncan Burton, and also thank the members for their short questions. Thank you very much indeed.
Thank you.
Okay, who's want to indicate for the next set? Okay. Okay, I'll start with the people I didn't get in on the last one. Okay, we're ready. We will now hear oral evidence from Mark Swindles, who is Assistant Director, who is Standards and Guidance at the General Medical Council, and Dr. Andrew Green, who is Chair of the Medical Ethics Committee at the British Medical Association. For this session, we have until 10:45 a.m. So could the witnesses please introduce themselves for the record and give a brief statement? And we start with you, Mark Swindles.
So I'm here from the General Medical Council, and the GMC, as the independent regulator of doctors across the UK, doesn't have a position on what the law overall should be on assisted dying, and similar to what the Chief Medical Officer said, we view it as a matter for wider society and ultimately Parliament. But having said that, we have looked at the bill, and were it to pass, we'd be obviously willing to work on things like the statutory code of conduct that it talks about to make sure the implementation works as best possible.
Thank you. Good morning. My name is Andrew Green. I'm a retired GP and I chair the Medical Ethics Committee at the British Medical Association. We had a very big survey of our members in 2020, and on the basis of that survey we moved our position to neutrality. All that means is that we neither support nor oppose any changes in legislation. What that position has enabled us to do is to reach out to people with a wide range of views and produce policy that we believe has broad support, looking particularly at the areas where it impacts on our members. We've had very positive engagement with legislators throughout the United Kingdom and indeed in the Crown dependencies too, with the aim not of supporting the bills, but with the aim of making sure that if a bill does go ahead, it works for doctors and for patients, because we've always believed that those things go hand in hand.
Thank you very much indeed. And just for broadcast purposes, can everybody make sure that they're as loud and clear as possible? So I call Dr. Neil Shastrihurst.
Thank you, Chair. Good morning, gentlemen. If I can turn to the issue of the initial discussion, which is dealt with at Clause 4 of the bill. And there has been some significant concern about whether doctors should be initiating that conversation with patients who are terminally ill or not. And I just wondered whether, as the bill stands under subsection 1, it says that no registered medical practitioner is under any duty to raise the subject of provision. And I'd be interested in your views on the compatibility of that element of the bill with the principles under Montgomery consent.
Thank you. Both of these items came about because of things that were in our policy, and we're pleased to see them in the bill. You are right. The thing that we mustn't have is assisted dying being just another tick box thing that doctors mention to patients that must not happen, and that's why we believe that it shouldn't fall within those two Supreme Court judgments that you mentioned. But there is another side to that coin, that we think that there are some circumstances where doctors should be able to mention this to their patients. If I can just explain why that might happen. Within the consultation, some patients do find it very difficult to bring up with their doctors sensitive subjects, even when they're the most important thing on their mind. And doctors are aware of this, and I hope we get very good at reading between the lines of what patients say to get at what's left unsaid. And in those circumstances, we need to be able to open the door for the patient to go through into a safe space to have those difficult discussions. And that's what we're talking about here. It's very difficult as a clinician to know when to have those conversations. The last thing that we would want when we're battling with that internally is to feel the weight of legislation behind us. So please do not pass legislation that makes it harder for doctors to understand their patients, because that's why it's important that in particular circumstances we should be able to gently raise the subject.
Yeah, if I could just add, so the GMC sets guidance on decision-making and consent, as you'll know. That is based on the existing law, including the case law on Montgomery, so it does put a lot of weight on patients having autonomy and their role, and the doctor's role to support that in the provision of information on different options, including the option of no treatment. But our guidance follows the law, so were the law to change, it would very much, we would look at it and accommodate. So we don't have a formulated view on what the eligibility should be, but we do know the BMA stance.
And from the Sorry, Chair. And from the GMC's point of view, have you undertaken a legal assessment on the openness of a legal challenge around that Montgomery point, if those conversations were not initiated and patients saying that they weren't given the full options available to them?
No, we've not done a forensic legal assessment of that nature, but obviously Montgomery's in case law, and what Parliament does have the power to set primary. But I listened to what the Chief Medical Officer said and what Dr. Green says in terms of how restrictive that might be or otherwise in terms of the doctor's role with the patient.
Thank you. Just might sound a tiny bit of a devil's advocate point, and fully appreciating you don't want to reduce this to, as you described, a tick boxing exercise. I guess the risk of what you're sort of describing, perhaps some may argue though, is an element of a lottery though, because obviously if you're relying on doctors to use their personal judgment as when to have that conversation, let's say for example the patient and the doctor don't have a particularly close or long-standing relationship, the doctor may not know what those signs are as you describe, and so a patient who may need to have that conversation may never have it. So I guess the risk is you're reliant on actually good relationships forming over time, a doctor to use their intuition, so actually the risk that opens up is that some patients will have the conversations they need to, others probably won't under the kind of system that you may be describing, I guess.
And obviously it would be great if we worked in a system where doctors had all the time they needed to deal with the patients. One of the things that we would like to see, there is a mention in the bill of a duty to provide information from the Chief Medical Officer, I believe. Reading the bill, to me it seems very much like this might be in the form of a website or leaflets. We actually believe it's important that patients should be able to access personalised information, and we would like to see an official information service set up that patients could go to either as a self-referral or as a recommendation from their GPs or other doctors that would be able to give them information not just about assisted dying, but about all the other things that bother people at this stage of their life. So social services support, the ability of palliative care. There could almost be like a navigation service as much as information service, and that might address some of the concerns that you have.
Thank you. Our previous witnesses, the issue of coercion came up, and our previous witnesses were very much talking about GPs and doctors and nurses should be able to sort of spot it because of the level of training and experience, etc., etc. I'm just wanting to sort of get a judgment from you as to how frequently sort of coercion or lesser versions of it, familial pressure, societal pressure, is a part of day-to-day life for a medical practitioner? Or is it something like with my asbestos awareness training that I had in the previous job, where I had it because I'm occasionally, very rarely, I might bump into it, or it's a tick box exercise?
You're right, all medical staff have safeguarding training, and of course patients make important decisions often with the influence and the help of their family members, and usually this influence is helpful, and it almost always comes from a position of love. The point at which influence like that becomes look at what's happened in other parts of the world that have more experience of this, because they have got, as part of their training, modules on this, and certainly we would expect capacity and coercion training to be part of the specialised training that doctors who opt in would go for, and I would anticipate that the general safeguarding training should be sufficient for other doctors who would only be involved obviously at that very early stage.
Thanks, Chair. I just wanted to talk to you a little bit about the process. I've been searching for kind of parallels in current practice, and I guess one that seemed close to me was if I wanted to donate an organ, a kidney, to a relative. Now, as I understand it, in those circumstances, first of all, the doctor is able to raise that possibility, even if I hadn't thought of it at the front end of that family decision. But then coercion and capacity are then assessed later by a trained individual. Would it be possible, do you think, to translate both of those into this situation? And then my second question was, as I understand it, the GMC already has guidance on dealing with assisted dying if raised by a patient, how doctors should handle that, and how easy how easy would it be for that guidance to be translated from what struck me as a kind of not hindering but also not enabling process towards something that was more informative?
Yeah, it's important to our guidance on assisted dying is framed in the current law, so it guides doctors to explain to the patients that that's not lawful for them to assist their patient to die, and it talks about the importance of explaining what other treatment options are available, including palliative care, and making sure that the patient's needs are met, and any other safeguarding matters. Our guidance does follow the law, so if the law were to change, we'd obviously attend to that. But it's not framed quite as you're suggesting that it assists doctors. So I wouldn't think that would lift and shift into what the guidance would need to be for doctors if this were to pass.
I don't have any experience with what you're describing, but certainly it would make sense to look at best practice in other areas.
But you're clear, though, that doctors should be free to have an open discussion with their patient about the whole variety of possibilities or paths that may be available to them as they face a terminal disease.
As a general principle, I don't believe that unnecessary barriers should be put in the way of communication. This is such an important area for patients that it's vital that they form a good trusting relationship with their key medical advisor, which would usually be a doctor. I also have to say that we have, at the end of life, we depend a lot on our specialist nurses, Macmillan or Marie Curie nurses, and it might well be that they're the person who the patient trusts most. But please don't put barriers in the way of understanding.
Because, I mean, just to add, sorry, Chair, we in the run-up to second reading, we did hear from some of the overseas experience that where there'd been effectively a kind of gag clause on doctors, it was proving to be extremely difficult and a big barrier for the medical profession, it felt, to discharge its duties. And you would recognise that issue.
Indeed, and I believe that in New Zealand, and I think it's the state of Victoria, I'd have to check that, there have been official reviews that have identified those concerns, and they're looking to review the legislation.
Okay, thank you.
Thank you. Just quickly on that last point, although it's noteworthy that in Australia and New Zealand, palliative care professionals are very keen on retaining that safeguard to ensure that it is not suggested to patients that that they might have an assisted death unless they brought it up themselves. So I think that's worth noting. And quickly, I've got a question for each of you, but just a quick clarification from Dr. Green. Is it my understanding, in terms of the survey, the official position of the BMA to be neutral? The majority in favour of neutrality, moving away from an opposed position, was the junior doctors and those not working with the elderly and the dying, whereas the great majority of doctors who work in palliative care and work with dying people remain firmly opposed to a change in the law. Is that your understanding?
There were some variations between specialties, that is true, but within all specialties there was a wide variety of opinion, and it's that wide variety of opinion that the BMA has based its policy on.
I understand. Thank you. Just a question for you, Dr. Green, on the delivery of the service, if it's brought into law. Is your understanding that the bill mandates the NHS to provide assisted dying service? I mean, appreciate that it's not clear in the bill, but nevertheless it does authorise the government to pay for it, and it establishes this right. So my question to you is this a medical procedure that we are proposing to legalise, and should the NHS provide it? And if the answer is yes, should that be a separate service within the NHS, or should that just be part of general practice?
We haven't taken a view as to whether it should be inside or outside the NHS. That's not for us to take. We do believe that it should not be part of any doctor's normal job to provide assisted dying. In other words, it should be set up through a separate service with a degree of separation. We believe this is important for patients because it would reassure patients who may be anxious about the service that it wouldn't just be part of their normal care. It would reassure patients that the service they were going into had proper quality, proper audit attached to it.
Okay.
It would reassure doctors, because doctors who didn't want to have any part wouldn't feel that it was part of their normal job, whereas the doctors who wanted to go ahead would be assured of having support, emotional support and proper training. And also it should hopefully reassure the providers who would then be assured that it wouldn't be expected of them just as part of their normal duty. So a degree of separation, we believe, is very important.
Okay, and quite quickly, if you would, what are the implications for resources then? Are you concerned? I mean, I appreciate that's your view, and I recognise that it makes very good sense. Are you concerned about resourcing of that service, and in terms of whether there might be implications for other parts of the NHS if this was to be a separate service?
I think we're always concerned about resourcing, and I can only back up what Dr. Whitty said about the importance of palliative care.
Okay, thank you. Mark, if I can come to you just quickly with a question about the actual end, the final act, as I think it's called in the bill. Do you think there needs to be more specific guidance on the face of the bill, or in a schedule, about what should happen in the case of complications? If the death is taking a long time, it can take up to an hour quite commonly in other countries. There may be complications again, that happens. What would happen if a doctor were to intervene to genuinely assist the patient to die if something was going wrong? Are you worried about the legal implications for doctors in those circumstances?
I would agree with you that there certainly needs to be really clear guidance for doctors on that scenario. What we've not taken a view on is whether that needs to be on the face of the bill or in regulation or in the statutory code of practice. What I would say is we'd be willing to participate in the setting of that, and I think it would be very important to listen to the view of doctors and indeed patients who might be interested in taking such a course of action to understand.
And just very quickly on that last point, it's not totally clear what kind of medical professional would be in attendance at the end. Do you think it should be a fully trained doctor? Should there be some separate professional with that role? How should that work?
I said not trying to duck the question, because we don't take a general view on whether the bill should pass or not. We've not taken an established view on the delivery mechanism for it.
Thank you. Thanks.
Thank you, Chair. Two areas. Can I start one with in terms of the current law? So I suppose I'm interested in the position that doctors are currently in, both regulatory and whatever, around the current law, which clearly under the Suicide Act, etc., prohibits this. So we've heard a number of us from families who've gone to Switzerland perhaps with etc., and who've returned and had a conversation with their family doctor around maybe the death of a loved one. We've got instances, I think, of people attempting to take their own lives. given there's no current assisted dying provision in this country. I wonder if you could just say a little bit about the current dilemmas facing doctors on the current law as it stands.
Yeah, so we do get inquiries from doctors concerned that they're doing the right thing when a patient, it might become apparent to them that a patient is wanting to travel overseas to access assisted dying. We've taken legal advice and on the basis of that we guide doctors that it's permissible for them to provide the existing medical records to that patient as you might do under, say, a subject access request. But to be really cautious about going any further in terms of things that like recommending that or assisting the process more than that, just based on our understanding of the existing law in the Suicide Act.
And of course, if I may, that leads on to a further issue that we've heard from Dr. Whitty today, that this may progress at a different speed between Scotland and England and Wales. And of course, we also have the Crown dependencies who are some way further ahead than either of the mainland governments on this. And this does raise an issue for doctors who work in England and Wales who treat patients in the Crown dependencies. And we would want clarity as well about the legal situation regarding a patient in Liverpool who is treating a patient in the Isle of Man. Should the law allow assisted dying in the Isle of Man?
Thank you. And moving on to the next issue, I think you both said, I think, fairly clearly around or advocated against having an absolute ban on doctors discussing this or raising this. I suppose I just want to tease out, is there a difference between raising it and recommendation? So I think, Dr. Green, you suggested maybe it might be appropriate for a doctor to recommend that someone seeks further information from an independent source, for example. If Parliament so wished, do you think it would be appropriate for Parliament to be clear that no doctor should be recommending assisted dying as a course of action?
I don't think I ever suggested doctors should recommend assisting dying. If I did, I apologise.
No, so the provision of information for someone that was...
The provision of information would be very useful, because in a situation where a doctor was unwilling to have an initial discussion with the patient, it would provide a way for the patient to get that information which was in no way obstructive.
So, okay, I'm just going to try again. So, some people are advocating that there should be a ban on this being discussed at all, which I think we've heard your answer on, both of you. I suppose a different version of that, a slightly different version of that, is a ban on any sense that doctors would recommend this as a course of action in the way that, say, an oncologist might recommend a course of chemotherapy. And I wondered if you could comment about that as a potential approach to assuaging some questions or concerns of the public on this, and how that would sit in terms of regulation.
We've not taken an official view on doctors recommending this, but I don't think it was ever in any of our minds that doctors would be recommending this as a course of action to patients.
So you would be happy if there was an explicit prohibition on recommendation?
I'm reluctant to make a statement on that in this forum. We will go away and discuss it and come back to you.
Thank you, Chair. Question that applies to both of you regarding clause 2, with the first doctor and the second doctor. Both doctors are required to, so for the first doctor, required to determine the patient that has a terminal illness, second, capacity, and the third one is not being coerced or pressured. And again, for the second doctor to make sure that the patient has a terminal illness, has capacity, and again, not coerced or pressured. I appreciate that Chris Whitty talked about doctors, and yourselves have talked about everybody being trained in capacity and coercion issues. But these doctors might never have met that person in the first instance who is now seeking assisted dying. And the questions that worry me, to be able to perform all of these actions in all cases without fear of misdetermining, the two doctors would have to be specialists in the relevant disease. So, for example, if somebody has a brain tumour or it's lung cancer or different types of cancers, would they have to be an expert in that to be able to determine that they're terminally ill? Or would they, from the GMC's point of view, would we find ourselves in a situation where doctors are working outside of their professional competencies and expertise? That's one point. And from the BMA's point of view, how do you protect doctors from finding themselves having to diagnose life expectancy for a disease they are not specialists in, and for determining capacity when they are not specialists in that, and determining lack of coercion when they potentially don't know the patient and don't have the experience of that. And finally, for both of yourselves, when the next step is taken and the court has to rely on the testimony of these doctors to protect the patient, are those testimonies, given all of these concerns, then safe to be relied upon by a court and by a judge?
Okay, so there's quite a few points there. Actually, working backwards, we have some existing guidance for doctors when they act as a witness, for example, in a court setting or other medical legal situations, and that talks in general terms about the importance of you being an appropriate witness. So inherent to that is some expertise and understanding of the topic you're assisting the court on. So I would suppose, again, that those sorts of principles would be ones that, if the bill passed in this form, and say again, the GMC's not got a view on what the sort of delivery mechanism or the bill should look like, but there may be applicable points from that guidance that would read across. I think you heard from the Chief Medical Officer about his caution about going down a condition-based assessment for this sort of thing. We wouldn't have a particular view on that, but there is one thing I wanted to highlight from the bill. It talks about specialism in the context of seeking advice from a psychiatrist. In terms of the GMC, the specialist register that we hold, there are actually 5 specialisms connected with psychiatry, so some clarity about is it any one or one particular one of those that the bill intends to cover would be good. I know that's not restricted in terms of the independent and doctor and the coordinating doctor roles from the bill either. But also we're aware that when doctors pursue a specialty in the sense that they become accredited and they go onto our specialist register, that doesn't fix in time what their individual scope of practice or expertise is. We know many doctors will go into slightly different fields or focus on one particular area. So one can't necessarily rely on the specialist register as a current indication of the doctor's area of competence in that way. What the precise delivery mechanism is and the point you make about should either of those two roles of doctor have seen the person, because we've again not taken a view on what the law should be. We haven't taken a firm view on any sort of process or eligibility, but I know the point.
Thank you. If I may, I'd just like to clarify my previous answer, having a little bit more thought. I do not believe it is ever appropriate for a doctor to recommend that a patient goes through assisted dying process. My internal thoughts was whether it should be on the face of the bill or contained in guidance or contained in good medical practice is the point that I was unsure about. With regards to the specific questions, no, I don't believe that a doctor has to be a specialist in the individual disease at stake to advise a patient about prognosis. I can only refer you back to what Dr. Whitty said, that in the majority of cases it is fairly clear. This applies to capacity too. There are some cases where it is not so clear, and what's important there is that the doctor has the ability to seek for further advice if they need it. It's not always required.
Thank you. Dr. Sandover?
A couple of points. Firstly, this in clause 4, subsection 5, it says that a registered medical practitioner, if they're unwilling to go forward with this assisted dying request, must, if requested, refer to another registered practitioner. Are you happy with that clause?
No, we're not, because we know from our survey that there are some doctors who feel very strongly about this, and the word referral to a doctor means writing a letter or communicating with another doctor to see, and there are some doctors who would find themselves not able to do that. So for that reason we believe that there should be an information service and then the doctor could direct there. So there is a particular problem with the word referral, but doctors wouldn't be able to be obstructive. They have the same duties under good medical practice as, for example, they have with termination of pregnancy requests.
Okay, thank you. And the other thing follows on from the previous question, is about the status. Now, I know the GMC and BMA have all other specialties of doctors underneath them. Would it be appropriate, in your view, for example, to have both doctors as general practitioners, or should there be provision for different doctors as a second doctor?
We've not taken a view on the qualifications of the doctors involved. We did have discussions about what grade they should be, for example, but we took the view that what was more important is their skill set and their training than their actual grade or their position.
And sorry, one further. Should there be a period, so in some legal medical situations you need to be post-training for 5 years before you can have a view. Is this something you would have in both of these practitioners, or is that not necessary?
We didn't take a view on that. We thought that training and experience was more important.
Okay, thank you.
Sarah.
Thank you, Chair. Actually, leading on from Dr. Ofer's question there about the must clause, if you like, the must refer. You and Professor Whitty both stressed the importance of the relationship between the doctor and the patient, and yet there may be doctors who feel very, very strongly against recommending assisted dying, not recommending, but mentioning assisted dying. Given the existence of the, I think it was clause 4? Five, beg your pardon, and the must refer. Do you think there's a danger that there might be doctors who would actually be reluctant to provide a prognosis of 6 months or less if they thought that that would make the patient eligible for assisted dying, and that simply wasn't something they could support?
That is why it's important that doctors should be able to opt out of any stage of this. There are doctors who would find it difficult to do that, and it's important that their position is respected.
Thank you, Chair.
Want to pick up, I believe, Ken Ledbetter
just
on that?
Point, thank you, Chair. Just on that point about referral, what happens in the case of abortion? Because it's one of the closest parallels we can get. So if we have a doctor who isn't comfortable having that conversation, presumably they can't just leave that patient with nowhere to go.
No, so what happened is that the doctor would provide the patient through their receptionist or through leaflets or through a telephone number with somewhere where they could get the information. You cannot just abandon a patient. They have to be sure that the patient has the ability to do what the patient wants to do.
Yeah, exactly. So the terminology might not be quite right in terms of refer, but we're saying we've got to provide that patient with a course of action.
Yes, it is the referral word that is problematic for us.
Yeah, okay, that's very helpful, thank you. And can I just pick up one more point, Chair? In terms of the GMC guidance around information about assistance to die, when that's raised with practitioners, part of the guidance there is that practitioners have got to respect competent patients' right to make decisions about their care, including their right to refuse treatment, even if this will lead to their death. So I'm interested in how that fits in with those very difficult conversations. And when a patient executes that right to refuse treatment, are those cases logged? Is it monitored? Is it reported on or not?
Yeah, so you think there was an important piece of case law, I think, in the 90s that clarified that a patient refusing treatment and subsequently dying that is not an act of suicide. So yes, you're right, our guidance does talk about the importance of a doctor explaining to the patient about, you know, the likely course of action in terms of the option of no treatment. Again, that's intertwined with the Mental Capacity Act, and it puts a lot of autonomy in the space of the patient, along with the consent case law that we covered before. Just on the previous point again about the issue of referral, so our guidance is similar to what Dr. Green was saying, in the case of conscientious objection, for example, on abortion, that the important point is to think from the patient perspective that they're not left with nowhere to go. So if that assists, you know, that may be a principle that helps read across.
And just on that reporting point of where patients take that right to refuse treatment. Again, obviously capacity must be assessed at that point if a patient has said, look, I don't want any more treatment. So that's quite an important point to assess capacity. And are those cases logged and recorded?
Yes, so it would be important for the patient's records to cover the points of consent and make, you know, the doctor's recorded that they've interacted with the patient that way. I wouldn't believe it's centrally held, but I maybe, you know, collated in any sense like that. I may be wrong.
Thank you.
Jane Richards.
Sorry, I just want to get some clarity on clause 4. I understand your, this is for Dr. Green, subsection 5 and the information services, as opposed to the referral to a practitioner. I think that has some weight. In terms of the rest of that clause as drafted, it has an opt-in, it gives wide discretion to practitioners, there is no obligation to raise it. It ticks all the boxes from my understanding of your written evidence. Is that fair?
Yes, with the exception of the referral.
Yes. Thank you. I just want to clarify that. Thank you.
And of course, much of section 4 we would regard as normal care in any case.
Yes, and there is, sorry, Chair, there is some amendments being proposed which would offer further clarification, more things that have to be considered. A similar question that I asked to the previous panel, I think you were here in the public gallery. Would that be welcome to offer further guidance for your members, or would you again err on the side of trusting their professional discretion?
As Dr. Whitty said, I think simplicity is the key here.
Thank you.
Liz Savinbob.
Thank you very much. Dr. Green, you mentioned the different jurisdictions within the United Kingdom, the Crown dependencies. What issues have your members raised in relation to this legislation?
In terms of the cross-border issues?
Yes.
Yes, I think the concerns are that patients particularly from the Crown dependencies, might be looking for some things, for example, like reports on life expectancy from doctors in the mainland. I think it is clear that if the doctor travelled to the Isle of Man or Jersey to do the work there, then the GMC would be happy with them, but we would want a clear understanding that they would not be at risk of any other legislative problems from, for example, the DPP.
Yeah. And of course legislation is progressing in Scotland, which has different definitions to that which we're discussing here as well.
Correct.
Yeah. With the GMC, I mean, any commentary about the fact that we have health devolved within Scotland and Wales, Northern Ireland, and a different set of jurisdictions in some instances?
So there are aspects where the law will differ, including on capacity, where, as a UK-wide regulator, we've managed to attend to that in our guidance so that, as best possible, we hope that doctors are clear on their responsibilities, where they lie either side of a devolved border. There's a nuanced point with the Crown. So in law, we are a UK-wide regulator. We know that the Crown dependencies and Gibraltar will choose to use doctors who are on the GMC register, but we don't sort of legally officially cover those areas, but we do. It does give us some regulatory purchase there. But if a doctor wishes to remain licensed to practice on the GMC register, there's a commitment to follow our professional standards.
Mindful of the time, this is probably our last question. Surgeon Joseph.
Thank you, Chair. What's your view on the accuracy of prognosis we make in this country? If somebody is told they may live 3 years instead of 6 months, may make a difference to their decision making. Does GMC or BMA have any data or studies done around the accuracy of prognosis?
We don't hold data. I've seen some of the coverage in relation to the bill and the uncertainty. I think we'd agree with a lot of what the Chief Medical Officer said to you about the stepped decision a doctor will make depending on the importance of the situation, and we try and capture that in our end-of-life care guidance, and would agree also the point about a doctor giving a central estimate. In that guidance we talk about issues, so for example taking a second opinion where there's a greater degree of uncertainty, the importance of doctors keeping up with sort of the latest clinical knowledge and efficacy of different sort of treatment courses to come to that determination. But we would agree there's inevitably a degree of uncertainty in that central ground that the Chief Medical Officer was talking about.
We have got a little bit of time.
Just very quickly, to clarify a bit on this referral issue. As I understand it, I may have it wrong, but in your 2013 guidance on medical practice and personal beliefs, it does say that doctors should refer in abortion, it should say doctors should refer to a colleague or service provider. rather than to a general information source?
I don't believe we use the word refer. We do talk from the... I'll double check that. We do talk about... Because referral, and I think this is part of the BMA's position, it has a meaning in the world of medicine. We do talk about the importance from a patient perspective and then not being left with nowhere to go. So there's some professional responsibility on the doctor to guide them.
Because my concern on the... I mean, I understand the BMA's concern, but my concern is that kind of here's a leaflet, you're on your own, or you can get information from this place. For somebody who's in extremis at that point in their life might prove to be quite a significant barrier for them, and whether doctors would reflect that in their sense of responsibility towards the patient, and we should leave that open rather than what is currently in the bill.
We would expect that to be done with sensitivity.
Right. So professional judgment again.
Order. If you'd like to complete your sentence, but we have come to an end.
That was my complete sentence.
Okay. Excellent. Perfectly timed. Order, order. That brings this session to a close. I want to thank the witnesses on behalf of the committee here. That's Mark Swindles, Assistant Director of Standards and Guidance at the General Medical Council, and Dr. Andrew Green, Chair of the Medical Ethics Committee at the British Medical Association. Thank you. And we're all ready with the Zoom? Yes, perfect. While we're waiting, do people want to indicate who wants to... do any of the members want to indicate? Okay. Got the first one? Yep. Got the second one? Yep. Okay, yeah. Oh. Oh, yes. Okay. Got everybody here. Okay. We'll now hear oral evidence from Glyn Berry, co-chair of the Association of Palliative Care Social Workers, via Zoom. Hello and welcome. And Professor Nicola Ranger, Chief Executive and General Secretary of the Royal College of Nursing. Now, for this session, we have until 11:25. So, could the witnesses introduce themselves first? If we start with Glyn Berry.
Good morning. My name is Glyn Berry. I'm a palliative care social worker and a lead allied health professional, and I'm co-chair for the Association of Palliative Care Social Workers.
Thank you. And I'm Professor Nicola Ranger, and I'm Chief Executive and General Secretary of the Royal College of Nursing, but previously was a chief nurse in acute hospitals for 10 years.
Rebecca Paul.
Thank you, Chair. This is a question to Glyn Berry, please. In your statement published in November 2024, you say there is a risk that without a more sustainable model of funding for palliative care, many people will choose an assisted death as the only way to escape from unbearable suffering. Can you just elaborate on why you say that, please?
Yes. As experienced social workers working within the realms of a society that quite often is split into have and not have, we already see the despair and difficulties that people encounter with inequitable care to palliative care services. We know that that a lot of services are delivered by charities, as well as statutory agencies, the trusts, and we know that the funding around palliative and end-of-life care currently is a real issue and has been heading that way for some years. In our experience professionally, and what we would hate to see that's been happening in other countries where assisted dying is already in place, is that people feel that they don't have an option other than to apply for assisted dying, because they don't know what else may be out there for them, and that is the role of a social worker. When we work with our patients, we look at the bigger picture, not just what's happening clinically. Obviously, we depend hugely on our clinical colleagues and expertise, but our specialism, if you like, is to look at what else is out there for a patient and their family and friends as well, because there is a part of the patient's journey as the patient themselves. But we also know that palliative and end-of-life care is hit and miss in terms of what people can access. Marie Curie report in 2024 showed that there are massive disparities in terms of better care for people at end of life or with a palliative condition. And it has a significant effect on people. What we say to people is we would help people to live as long as they can, as well as they can, in palliative and end-of-life care situations. But that's really difficult when the resources aren't there to be able to do that, and things become a huge priority.
Thank you. And I mean, what would a more sustainable model of funding for palliative care look like?
Slightly going off topic. If we can have a brief answer, because that's slightly going off topic.
Sorry. It would be something that was equitable for everybody, and right at this moment in time, it isn't. As I said at the beginning, some people get it and some people don't. And a sustainable model would be around fair access to everybody.
Thank you.
Tom Gordon.
Thank you, Chair. Obviously, the bill in its current form looks quite heavily at medical professionals. We've already heard from lots of experts in that area. I think, obviously, one of the things that social care and palliative care often deal with are those really hard, difficult conversations. What lessons and advice do you think you might be able to give, and how might you be able to feed into an input in this process?
Thank you. So, we work very closely with clinicians and other health professionals, and we talk about a multidisciplinary approach, because a person isn't just a two-dimensional person. There's everything about their life needs the input of other people in these situations. In terms of a social worker, our expertise and strength, if you like, is being able to ask difficult questions, being able to really dig into people's thoughts and feelings and opinions, giving them an opportunity to sometimes say things that they've never said in a whole lifetime. Our other areas are around capacity, assessing capacity, and giving people the options of knowing that there isn't just one way of doing things. As an example, I work in a hospice setting and have done for the last 6 or 7 years, and I see daily how social workers contribute to the wider MDT in terms of safeguarding, in terms of capacity, in terms of applications for deprivation of liberties. But we also do that psychosocial aspect of palliative and end-of-life care. We sit and talk with patients, we advance care plan, we deal with some of the practical aspects of supporting to arrange funerals. For families where a parent or a primary caregiver is the person who is ill, we will work with external agencies, statutory agencies such as local authorities, to support where there may be children or vulnerable adults who are being cared for by the patient to have provisions put in place for after the death of the person. And we also support with pre and post bereavement support of both with the patient and family, and with the family post bereavement. So we have quite an extensive skills catalogue to support patients and families. But I think one of the biggest aspects and skills that we have is that communication, and not being afraid to go where perhaps other professionals may feel uncomfortable going. Having conversations about people wishing to end their life, it's not actually a new thing. We
Can I just
have those conversations quite regularly. Sorry.
Yeah, no, that's fine. Thank you very much. That's really, really helpful. And I'm just wondering, in terms of then, for people like yourself and organisations like yours, what do you see your role in the assisted dying process has been? And do you think it might be better if you were further involved?
So in our association, we have a list of recommendations, and we're very conscious that the bill itself is very heavy from a clinical perspective, and there are a number of things. We don't feel that the decision and assessment should be primarily all on the shoulders of a health professional, the clinician. Some clinicians are fantastic with assessing capacity and being aware of the safeguarding aspects of situations, but not all are. We feel that our expertise lays in that particular area, but also as part of, so when we look at the overview of the process set out in the bill, it is very, very clinical, and there isn't anywhere, just looking at the overview, where it talks about the clinician exploring the other aspects of a person's life. It is very much around the clinical aspect, quite rightly, because these are experienced clinicians. So we feel that we should be involved in these decisions from the capacity and safeguarding aspect, but also looking to see whether the things that we can do to help that person make a more informed choice. Because if their decision to take their life is based on the fact they haven't got secure housing, their benefits or finances are all over the place, they don't want to be a burden on their friends or families, or indeed have nobody at all. Those are areas that are very, very familiar to us and what we do on a daily practice, and therefore we feel that we are well placed to be in that position of supporting the clinicians in the whole process.
Yeah, no, thank you very much. I think that was a really comprehensive answer, and I think the sort of key point you touched on there is that multidisciplinary approach. So, I mean, fantastic. Thank you very much.
Juliet Campbell.
Thank you very much to both of you here today. During this whole discussion, for many, many months, there's been a lot of talk around palliative care and pain management, and which can lead patients to come to a decision or to consider assisted dying as an option. If a doctor, so my question is, if a doctor has suggested to a patient that assisted dying is an option, or a patient has said that they are considering assisted dying, do you think that they should be referred to another clinician, or do you think there should be an independent organisation that is a non-clinical setting where a patient can go to have further discussions before taking that route onto assisted dying?
I think there's something...
It's to the Professor.
Yeah, thank you. I think there's something really important about a big difference in the beginning with regard to palliative care and assisted dying, with regard to pain control, pain management. It's absolutely essential those two things are slightly separated, because it would be heartbreaking to think that someone would, that would be the primary reason that someone would want to assist in having their in dying because of pain management, because we should be able to control and support someone's symptoms and pain. the primary thing, I think, as you said, with regard to being referred to another organisation is around autonomy. And I absolutely agree with what was said earlier. You would want anyone that is considering assisted dying to be slightly separated out of their normal clinical pathway. So not part of mainstream care for someone in a hospital or in an organisation. So there's something really important about separating that out, both in the discussions around this decision making and any care involved in assisting them to die. So I think those two things do need to be separated.
So rather than going straight to the route of I've made this request or this has been suggested to me, right, this is the path that we're going down, there's something that should happen in between.
Well, you wouldn't really want any clinician to assess, sort of push this view on any patient. It has to come from the person themselves. And that's the key thing around capacity and autonomy. I don't think it should be something that people ever say to a patient or an individual, is this something you've considered? It has to be led by the patient.
Thank you. Thank you.
Dr. Murray.
Thank you. So Professor Ranger, please, just picking up on some of the points that Glyn Berry made in relation to the different circumstances that certain patients find themselves in. We know barriers to healthcare as a result of health inequalities, access to education and disability are well documented. How could your members help remove barriers to such groups in accessing the provision of assisted dying?
It is absolutely vital that any of those barriers are removed and that we always maintain, outstanding care at the end of someone's life. And in reality, majority of palliative care is given by nursing staff, whether it's in the community, someone's home, a hospice or a hospital. So the majority of palliative care is given by nursing staff. And it's absolutely key that as it is an expertise, it is specialist practice, it is something that someone is both extra training, extra education, and really have those skills around listening to patients, advocating for them, and ensuring that they are pain-free at the end of their life. So I would say that those skills now are something that nurses have, and it's absolutely vital that our nursing members continue to maintain that. And they are often the person that a patient or a person will speak to at 3 a.m. when there's no one there. And I think it's absolutely vital, as Glyn said, that wider team is absolutely included in this bill. And we know the bill talks about it, the guidance and the recommendations being for the Chief Medical Officer. But when the majority of care is given by nursing staff, I think it's absolutely vital that the Chief Nursing Officer is a key part of the guidance and the drawing up of any care going forward, because that is who will give, even in these circumstances, the majority of the care.
And just to pick up on your important point about advocacy, if coercion, undue pressure or dishonesty by family members or other supporting parties that the patient was relying on in relation to that patient seeking assisted dying, how would your members detect that there may well be that coercion, dishonesty or pressure from such individuals, and at what point would a report to the police take place by your members?
Safeguarding is part of our professional responsibility now. So that is part of your role, actually, whether it's a child, adult or an elderly person, to be vigilant around all of those things. Financial, misconduct, physical abuse, mental health abuse, any of those things is a responsibility of every nurse now, actually, and it's a very good and simple process. You do not have to investigate or give a judgment. You need to refer for it to be investigated, and that takes the pressure off an individual clinician. Our job is to be vigilant and to refer safeguarding anywhere where we think there is of any form of abuse. And I think that process would still remain and could be part of how we do things now.
And just to follow up on that, because it's really important, so you think that your members would have the ability to pick up on such coercion, dishonesty and pressure from other parties on potentially being placed upon a patient who is seeking assisted dying, and what other training or support would be needed for your members?
We would want more support, so I'm not going to say that we don't always get it right, because sometimes things happen and we miss them or we don't report. So I can't say we get it right 100% of the time. But when it talks about education and training for medical staff within the assisted dying bill, it's absolutely vital that nursing staff are included in that, because we will need to be very vigilant around anyone feeling that they're a burden. I think that this bill would add other skills that we would want to make sure that nurses were included in. That education for medical staff is absolutely pertinent for nursing staff, so they build on skills they already have, because there will be a difference between the care of someone wanting assisted dying and palliative care. They are two slightly different skills, and I think it's really important that those are always not lumped together. And actually, if you are involved in assisted dying, that is a specialist skill that will require specialist training, and we would very, very much want nursing to be included within that.
But you would believe that your members would be able to pick up on and identify issues like coercion?
I do. Yeah,
Thank
they're
you.
professionals, and I believe they would.
Thank you.
Thank you, Chair. My question's for Glyn Berry, if that's okay, and it's just diving a little bit along some of the points that were made earlier. I think your organisation has recommended the new role of an approved palliative care professional, and just kind of, as they kind of get into detail a little bit more, you make a number of recommendations of what that role would include. For example, ensuring that a person has a mental capacity to make the decision. Are you saying, therefore, that you believe this new role should sit alongside the two doctor processes as sort of already outlined in terms of that kind of final decision making, i.e. if they felt, for example, that the person didn't have the mental capacity, this approved palliative care professional would have the ability to stop the process, as it were? And secondly, what sort of level of training would that person need in terms of time? So, i.e. we've been talking about a 2-year process, so if this new role was to come into effect, how long would this person need to be trained for to be able to adequately fulfil the role? And do you have a sense of how many of these professionals we would need in order to kind of make this a functioning system as well? Sorry, 3 kind of separate questions within that. Oh, sorry, directed to Glyn Berry, sorry.
Sorry, so to answer the first question, we do feel that the role of an approved palliative care professional would sit beside the clinicians for reasons that I outlined earlier, to have that balance, I guess, of clinical and social observations and assessment. In terms of the training, as social workers, we already have the continuous training opportunities of becoming best interest assessors and practice educators, approved mental health practitioners. So we envisage that the training would very much be along those lines. To currently do the roles that I've just mentioned does require a course of training currently at university, and in terms of numbers, our thoughts are that at this moment in time it would be around palliative care social workers, whether they were in charities or trusts, local authorities or independent, because that is where things sit with us at the moment. We know our roles, but we like to think that would roll out in terms of other professionals, because in terms of assessing capacity, it isn't specifically the role of a social worker. Other professionals are able and do complete capacity assessments In terms of numbers, that's quite difficult to answer at the moment, but if we were talking specifically around palliative care social workers, at this moment in time we have around 200 members in our association, but there will be other people out there that are maybe, are not members and we don't know who they are. But it's a role that could expand. And one of the other things that we made in terms of a recommendation is that palliative and end-of-life care, which is an aside to your questions, is that palliative and end-of-life care is also brought into qualifying roles for people in training, such as doctors, nurses, allied health professionals, as well as social workers, it's something that we could see could go in the future.
Thank you, Chair. Thank you for coming and giving evidence today, and thank you for meeting with me recently. You represent organisations that have both got a neutral position on assisted dying. Yeah. I'm really interested in what you're talking about in terms of this multidisciplinary approach, and I think it's a really valuable conversation, so thank you for raising those points. I want to ask a bit more about what this end-of-life conversation looks like in your experience, because you're absolutely right, from all the people that are spending time with patients in their last few months of life, it's often nurses, it's often palliative care social workers, so I think you've got a really important role to play. But I'm also interested in terms of what this would actually look like in reality. And there's been sort of talk of kind of a separation of palliative care and assisted dying, but actually I think what we should be looking to do is embrace a holistic approach to end-of-life conversations and end-of-life care, which is indeed what's happened in other jurisdictions. So you'll have a patient who might actually sign up for assisted dying but never does it because they have good palliative care and they work with their palliative care experts and specialists. So I think it's important that we don't try and separate these things. And actually one of the strengths, if you might give me your views on this, is that having these conversations about death, about dying, about end of life is a really positive thing. But I think your members have got a really important role to play in this. So could you talk a little bit about, maybe for you, Professor Ranger first, that holistic approach that your members take?
You're right in regard to the conversations and the care around dying, and having those conversations with people around pain, around pain management, symptom management. That is the role, particularly of palliative care nurses. But when the assisted dying, I think sometimes the conversation is slightly different, actually. So just talking more as a nurse here in some ways, because the primary reason that assisted dying is often a discussion is a lack of autonomy, not pain. So the conversation tends to go genuine in a slightly different way. Symptom control, being scared of pain, understandable, and we absolutely have the ability to be able to have that right for people. But actually, when it comes to seeking assisted dying, the primary reason is usually autonomy rather than pain and fear of dying. So in a practical way, I think an experienced nurse, an experienced doctor will start to gauge the difference in those conversations because they are different. And I think it's being really clear around those conversations and really listening to what people have to say, and then having a way to be able to ensure that what an individual wants is something that you've got, that you listen to. And I absolutely agree with Glyn around safeguards, around all of those things that we need to absolutely make sure are there. But the whole point of assisted dying is to not to be paternalistic, but to respect autonomy. And whatever safeguards we ever put in with that, we've got to be really careful not to ignore that right of autonomy, which is primarily what this bill is trying to preserve. So I think it's about being really vigilant, really listening, but a primary role of a nurse is to advocate. Not your personal view, but to really listen to somebody else and to ensure what they want is pursued. And I think in all of that discussion, it's really important that doesn't get lost.
That's incredibly helpful, thank you. And you're absolutely right to bring it back to that patient autonomy, that patient choice, while putting all the safeguards in place so that we're very clear it is their genuine choice, and it is a choice based on what they really want to do. And it sounds as though you're saying that your professionals are trained to have those conversations, which is very reassuring. Yeah, brilliant, thank you. And Glyn, do you want to add anything?
Just to say that Professor Ranger, I absolutely agree. My experience of working with palliative nurses and nurses in general is long, historically, and I have exceptionally positive experiences and continue to do so. And I think we learn from each other. And I think what's really important is that we can have those conversations with the person and ask questions that they might never have been asked before, such as, what is it that you want? And I think, again, Professor Ranger is absolutely right in terms of the autonomy and the person having control. It's because once that diagnosis is given, it can be a downward spiral for a person, and they feel that they lose control, and patients talk about this and families talk about it. They have no control over what's happening, and to effect that is true in terms of what is happening from a disease, an illness trajectory, but actually it's so important to remind a person that they are still the person that they were before that diagnosis, and they will continue to be that person, and that they still have a voice. And I think both of our roles professionally and alongside other clinicians, that is what we seek to do all the time in our work, and that is why an MDT approach is so important. And ultimately, if we find that once you've asked all the appropriate questions and you've put potential safeguardings in place following conversations, a person may not choose at that particular point to end their life, as you'd mentioned, Kim, a few moments ago, and may actually continue to live to the end of their natural life.
Sir John Joseph.
Thank you, Chair. When the RCN's Scottish director gave evidence to the Scottish Parliament during the discussion around Scottish assisted dying for terminal adults bill, he expressed the RCN's concern that there were not sufficient safeguards in place to protect nurses and nursing practice around assisted dying in Scotland. Are you satisfied that the bill we have before us in England and Wales address those concerns, or would you like to see amendments to ensure that the mental health and well-being of nurses involved in the process are protected should this bill become law?
Yes, I think we would want to see more support and protection for nurses. Of course, in Scottish legislation or Scottish exploring of assisted dying, the second clinical decision maker is a nurse in Scotland. So it's a doctor and a nurse, whereas in England and Wales we're looking at obviously two medical qualified practitioners. So we absolutely do want to make sure that the skills and the support is there for nursing staff, and also as the ability, as I heard was saying with our medical colleagues, the ability to not be involved in assisted dying absolutely has to be supported. So it can't be an expectation of the role. It has to be something that you choose to proactively take part in as a conscious decision. It cannot be something that's ever just an expectation of a nurse, and we're absolutely adamant about that. And we do think that this bill cannot just support the needs of medical staff. Nursing absolutely has to be included within that, both in skills and also support.
Well, thank you. Professor, I just wanted to test a little further on this notion of a separate organisation that you mentioned earlier, because I can understand a sort of separate discipline emerging, acquired by training, which obviously is what happens in palliative care at the moment. But we heard from previous witnesses that simplicity in terms of safeguards was key, and also in particular from the CMO that we had to avoid the last 6 months of someone's life being a bureaucratic kind of nightmare. And given that you, at the moment, within palliative care and palliative nursing generally, you're already dealing with patients who are electing to refuse treatment, to refuse food and water, or indeed to support patients following an advance directive. If you're supporting people in those circumstances as they move towards their death, do you think that it could be absorbed within the current functions rather than having a separate organisation?
It's difficult. I mean, and if I'm honest, we haven't probably explored that enough as a college within our thinking. But I think there's something about what we know what we wouldn't want to see, whereas an expectation that it becomes part of a pathway. It's got to be something you actively seek and opt into. So how that is completely administered, I think, if I'm honest, I think it probably requires more thought. But what I wouldn't want to see is it becomes an expectation of a pathway, because then I think the pressure on the individual may change, and that's a safeguard that I think we need to guard against. But I am worried that you don't want to make it so bureaucratic for the individual that it becomes just absolutely impossible to actually have your autonomy respected. So I think how that happens is going to be something that needs further exploration. So I think we would fully support making it as clear and as unbureaucratic for the person as humanly possible, but not see it almost as a sort of pathway within our current setting, because I think there could be that sense of this is something that has external influence rather than being something that someone actively seeks for their autonomy.
Thank you.
Thanks very much. You've obviously done this very powerful report, The Last Shift, which talked about the moral injuries, a very powerful phrase, felt by nurses in light of the shortages in care, in the NHS and in social care. Can I ask you what a nurse or indeed any health professional should do in circumstances where a patient is requesting assisted dying and qualifies for it, when that professional thinks that what they really need is care, palliative care, but it's not available because of the shortages in the palliative care system? What should they do in those circumstances?
It is difficult, but I think from my experience there are ways to try and get people palliative care, whether that is, as we said earlier, whether it's via other organisations outside the NHS, within hospice care. So I think there are ways through the current routes to get people the care that they need.
Sorry, just to be clear, you think it's possible for every patient who needs it to get the palliative care they should have?
I don't think it's as good as it needs to be. We know that it's hard sometimes for people to access the care. We know the struggles on hospices. We know far too many people die in hospital. So we know there are real challenges on social care and health service. So I can't say it's not without challenge.
So it could be possible that somebody's requesting assisted dying because of the absence of adequate palliative care.
I think when you put it in a question like that, it could be possible.
Okay.
But what we would want to strive to do is have a system that doesn't leave anyone in distress.
Well, indeed. And lastly, very interested in your suggestions about a separate service and about the importance of protecting the rights of professionals who don't want to be involved. Do you think, Jenny, I can't decide for myself what the answer is. Do you think it should be possible for a care home director? I was very conscious of the plight of care home workers in the pandemic, and I regretted my vote to mandate the vaccine to them. People working in care homes, do you think it should be possible in the bill for the director of a care home to exempt their whole service, that care home, from being involved in assisted dying? This is where people live, after all. And if somebody's having it there, it could affect the entire, well, certainly the atmosphere of the place, but also the work that all of the people working there have to do. Do you think they should be protected as an organisation?
I think particularly for nursing homes, I think that would be difficult, and I think that's something as to how and where people end their life probably needs further thought and further explanation. And I think there's something about being really clear. If you're the leader of that nursing home, we would have to explore your ability to be able to advocate as the care you want to be able to give in that nursing home. So I think all of these quite practical things need really further exploration. But it is difficult because for someone that maybe wanted to end their life, if that's their home, they may want to be there. So I think it's all of these practical things that probably need further thought and exploration, because I think it could be argued either way.
Okay, well, we've got about 40 seconds left, so I don't think we will get in another question, but I just wanted to ask Glyn, in the final 30 seconds there, is there anything you wanted to add to any of the points you've heard?
I don't think so. I think that was a really good question, the last question around care homes, and I'm just already thinking about implications for registrations of the CQC and what that would mean in terms of the process and the protection of staff and residents and families. I think that's a really helpful question to think about. Thank you.
Order, order. That brings us to the end of this allocated time for the committee to ask any questions. I want to thank our witnesses on behalf of the committee. Glyn Berry there, co-chair of the Association of Palliative Care Social Workers, who was on Zoom, and Professor Nicola Ranger, Chief Executive and General Secretary of the Royal College of Nursing. Thank you all very much indeed.